Good day, Crime Talk aficionados. We have a great show for you today here on Christmas Eve. First, a further breakdown of the Mangione charges. Why did no one help the woman on the subway in New York as she burned to death? Is there an alternate suspect in the Bryan Kohberger matter? A Georgia couple gets 100 years in prison for one of the most heinous crimes one can commit. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill by now. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out anytime on any of your favorite podcasting apps. Yes, it is also December 24th. Happy Christmas Eve. Hope everyone has a Merry Christmas as well. Now, let's go ahead and just get straight to the show today. First, Mangione, Luigi Mangione. As you may know, charges have been filed separately in both state court and in New York and Pennsylvania, as well as in federal court in Manhattan for a total of some 20 counts. Now, the charges against Mr. Luigi Mangione is both a terrorist and a stalker. They accuse him of carrying a ghost gun and a fake ID and enable prosecutors to seek life in prison sentences, as well as the possibility of the death penalty in federal custody. That's not going to happen. So anyway, on Monday, in the last of the three court appearances in 5 days, Mr. Mangione pled not guilty in New York State Court for an indictment charging him with 11 counts in connection with the December 4th killing, as well as murder as a crime of terrorism. Now, Mangione's state court arraignment followed back-to-back hearings last Thursday in Pennsylvania, where he was arrested on December 9th, in federal court in Manhattan, where a judge ordered him held without bond for the murder, gun, and stalking charges. Now, Mangione's lawyer has argued that the terrorism allegations in the state case and stalking charges in the federal complaint appear to be at odds with one another. He said that prosecutors are trying to treat him like a human ping pong ball and some sort of spectacle. Anyway, here's a look at the cases and the charges involved. First, New York, 11-count indictment, including a count of terrorism in 2 counts. Now, the Mangione state court indictment alleges that he killed Thompson to intimidate or coerce a group of people and influence government policy by intimidation or coercion. Now, I think those 2 first counts in the state case are completely overcharged, and they should just go with count 3, second-degree murder. But, hey, it's Alvin Bragg, the worst district attorney in the United States of America. The state court indictment there in New York also includes 3 counts of murder, alleging that Mangione killed in furtherance of terrorism as an act of terrorism and with the intent that carries a maximum sentence of life in prison. Like I said, the Manhattan District Attorney, Alvin Bragg, worst DA ever, office is prosecuting this case, and last week said that the ambush was a killing that was intended to evoke terror. Now, the indictment also charges Mangione with 7 gun-related counts and 1 count related to a fake New Jersey driver's license that prosecutors allege that Mr. Mangione used to check into the Manhattan hostel when he arrived in the city some 10 days before the killing. Well, prosecutors anticipate the state case will go first to trial, and then the federal case will then proceed. Now, after the arraignment on Monday, Mangione was returned to federal jail in Brooklyn, while state and federal authorities sort out where he'll be detained while the state case plays out. In the federal court case, there's 4 counts, including death penalty eligible charges. And then a day after Bragg announced Mangione's state indictment, federal prosecutors up the ante with a 4-count criminal complaint that could bring the death penalty if he's convicted. Since currently, there's only 3 people on federal death row, and they did much more heinous things than just a single murder. Unlikely that Mangione will ever get the death penalty, let alone in New York. Well, the federal charges also have 2 counts of stalking and 1 count each of murder through use of a firearm and a firearm offense. Now, murder through the use of a firearm carries the possibility of the death penalty, like I said. prosecutors haven't said they're going to do that. I wouldn't hold your breath in any way whatsoever. Now, like I said, Mangione has made an initial appearance on those charges before the federal magistrate judge last Thursday, but was not required to enter a plea. The United States Attorney's Office in Manhattan has until mid-January to secure an indictment from a federal grand jury. That is not uncommon in the federal system. Oftentimes people are charged with an information, and then once the federal grand jury meets, because the federal constitution requires anybody charged in federal court must be charged via indictment, that indictment will be returned. Now, according to the federal complaint, Mangione has a spiral notebook in his possession with expressed hostility towards the health insurance industry and wealthy executives. Now, United Healthcare is the largest health insurer in the U.S., though the company said Mangione was never a client of theirs. Among the entries, the complaint said, was one from August that said the target is insurance because it checks every box, and one from October that describes an intent to whack an insurance company CEO. Now, in Pennsylvania, there is a 5-count complaint and information against Mr. Mangione. That includes gun possession charges and false ID. As you may recall, Mangione was arrested on December 9th in Altoona, Pennsylvania, about 200 and some odd miles from New York City, and initially charged with the possession of the unlicensed firearm, forgery, and providing false identification to the police. Now, the Blair County prosecutor there said last week that he intends to keep the case active and plans to revisit it once Mangione's murder charges are adjudicated, which is code for if he is convicted in New York State or in federal court, those charges were going to be dismissed. It gets interesting, ladies and gentlemen, when you have all of these different sovereigns, as they're told, prosecuting different people. Now, normally, since he's in primary federal custody, he's going to be at the federal detention center, and they're going to have to writ him to the state courts back and forth. It's kind of monotonous, and it is kind of a pain in the butt. Now, I'm sure that they will get Mr. Mangione there because he is a high-profile guy, but at the reality of it, at the end of the day, the state's probably going to go first, and then if there's a conviction, maybe there'll be a concurrent plea. Like you see lots of times, the feds like to take cases that they know are nice and pretty with a nice little bow on top. If there's any doubts, they let the state go first, or they just let the states handle it entirely. And as we learned the other day, the reason the feds picked it up was that the insurance lobby thought that there needed to be some real charges against Mangione to deter copycats because the insurance industry feels unsafe. Next, let's talk about that woman in New York City that got burned to death. Why did nobody help her? Now, we brought you this story yesterday, and if you've seen the pictures, they are absolutely horrifying, ladies and gentlemen. But what we know right now is that an illegal immigrant from Guatemala set a complete and total stranger on fire on a New York subway station, and he has now apparently told police officers, well, he believes that he was drunk, and he really couldn't remember much of what went on. Fortunately for the state, doesn't matter. Mr. Sebastian Zapata Khalil, guess what? It means he's probably going to prison the rest of his life if he is convicted. And then if he ever gets out of prison, he will then be deported. So Mr. Zapata has been charged with murder and arson in the first degree after the woman, who has not yet been named. I know there's been some reports of a name, but it hasn't been verified by police authorities, so we're not going to throw that name out there out of respect for everybody, all right? But the woman who's not officially been named was burned to death on the F train in Brooklyn on Sunday morning. Now, police say that Mr. Zapata lit the unarmed passenger on fire as she slept on board the train before sitting back to watch her burn as she leaned, dying on the subway floor. Now, Mr. Zapata was arrested a short time after with a lighter in his pocket, and then he told investigators he was drunk and he had no recollection of what happened at all. Now, he was pictured in a perp walking out of the 60th precinct in New York City in Coney Island on Monday afternoon, And the victim has not yet been identified. Now, footage showed the moment a man in a hoodie sat on the platform at the Stillwell Avenue and Coney Island train station there, subway station, and watched as the woman became engulfed in flames. Now, Zepeda can even be seen fanning the flames in one clip, while other New Yorkers filmed the horror on their phones and the police walked by. Now, some people are saying that Zepeda was in the country illegally after previously being deported from Arizona at the border there back in June of 2018. Now, it's unclear exactly how he got back into the United States, probably just by walking across the border. When Mr. Zepeda appeared stone-faced, his officers escorted him out of the Coney Island building. Now, he fixed his eyes on the ground while wearing his little white overalls there. And the video of the subway arson attack caused an uproar online over how police at the scene appear to be, well, not responding. As literally the woman burns and the suspect sits on a bench nearby, an NYPD officer can be seen walking by, waving his hands over the scene in exasperation. He doesn't intervene to detain the suspect or to help the victim in any way whatsoever. No one helped. The bystanders were too busy filming. The police, well, instead of wrapping their jackets around the burning woman, they just walked by. Then there was Mr. Zepeda, the man charged with the lighting of the match and set the innocent subway rider on fire, just sitting there and fanning the flames. Now, the picture of the female figure standing like a zombie while her torturer sits on a platform to watch her burn is just outrageous. Surely someone would have thrown their coat over her, ran over, grabbed some water, screamed at her to stop, drop and roll, found a fire extinguisher, yelled for help, something. Most of us like to think that maybe we would do that. I'd like to think that I would do that, but nobody did anything. But now this woman is dead. The whole scene is, obviously a gruesome killing. And I don't know, it kind of says how dysfunctional maybe New York is, or maybe society has become, where we're more concerned about videotaping something than actually helping somebody. Like I said, Mr. Zepeda, we'll give him the presumption of innocence because he's entitled to that, but he could have done something. He apparently doesn't fear the police or any consequences for breaking the law in any way whatsoever. I said the other day, where's Daniel Penny when we need him? We need entire subways and buses filled with Daniel Pennies instead of people that are more concerned about getting away from the situation or filming it. I said the other day, where's Daniel Penny when you need him? At least he had enough courage to step in and stop somebody who was threatening to do something. Here, nobody did a single thing, and it's absolutely tragic. And Alvin Bragg, he'll probably ask this guy if he needs a ride back home to Guatemala since he helped Daniel Penny get indicted. Thank God the jury did what they did. But I think the result of that may have been some indication why nobody did anything in this particular case. Oh my God, if I help, am I going to get charged? Did I do enough? Am I going to be criticized? We need subways full, buses, airplanes full of Daniel Pennies, ladies and gentlemen. That's the only way it's going to get done. The police aren't doing it. They're not, for whatever reason, they're not protecting the people. You're on your own. I've said it before. At the end of the day, you are the only one responsible for protecting you and your family. And I think that is becoming more and more evident every day. Next on the docket, Bryan Kohberger. Is there an alternate suspect? Well, there's a little bit of a twist in the Kohberger case. Now, police are now saying that the suspect, Bryan Kohberger, was investigated in connection with an earlier home invasion. So body cam footage shows police responding to an alleged home invasion 1 year before the murders, less than 10 miles from the off-campus home where 4 University of Idaho students were stabbed to death. Now, the woman in the body cam video tells police it was about 3:30 a.m. in the morning when a masked intruder entered her bedroom in Pullman, Washington, and this intruder was holding a knife. She said that she heard her door open and she looked over and someone was wearing a ski mask and had a knife. And she kicked the person in the stomach. They flew into my closet. Then they ran out the door and went up the stairs. Now, according to the police report, she said the suspect was silent the whole time. And while one of her roommates quickly called police, officers found no suspect or evidence at the scene. Well, months later, then we have the Kohberger. Bryan Kohberger was arrested for stabbing Kylie Gonzalez, Madison Mogen, and Zaina Kernodle and Ethan Chapin there in Moscow, Idaho. And in that incident, the killer also allegedly had a knife, wore a mask, entered the home in the early morning hours, and was silent as he left. Then, 13 days later, Kohberger from Pennsylvania was named as a person of interest in the Pullman case. And when you look at the Idaho murders, one of the things detectives and agents did almost immediately are there other cases that might have some similarities? For example, were there any fingerprints, DNA, hair samples, anything that you could either biologically or genetically or fingerprint-wise link the suspect to that particular burglary? But according to the report, the woman described in the Pullman incident said the suspect was 5'3" to 5'5". Well, Kohberger is 6 feet tall. Now, those type of things at night in a stressful situation could be off indeed. The report also reveals that the Pennsylvania resident was not yet enrolled at the Washington State University, nor was he visiting the campus as a prospective graduate student at that time. The plot thickens. Anyway, the Pullman police say that Kohberger is no longer a person of interest in that break-in, and they said that they have no reason or evidence to believe that he was involved in the burglary at this time. The case is now closed but remains unsolved. So the growing question is whether the defense now is going to try to maybe introduce this other burglary where somebody has a knife in the house, very similar to what took place in Moscow, Idaho. Yes, indeed. But do you know who it is? Can you get it in? What are the legal relevancy rules about that? Certainly on cross-examination, anything that the detectives did to look at alternate suspects certainly can raise that question. The defense could even bring the victim in that particular case to say it happened. And, my estimation of the height could have been off because it was dark. I had just woken up. It was a heat of the moment type of situation. And I could be estimating, but I could have estimated incorrectly. Alternate suspect in the Bryan Kohberger matter? Now, in all honesty, the judge may not give a whole lot of deference to the defense on this particular issue, but I would think the defense is going to try to use it to raise some reasonable doubt by pointing to this alternate suspect and using this alleged burglary. The question is, like I said, is the judge going to allow that evidence in? Maybe limited inquiry, but the fact that the victim doesn't say that the suspect, Mr. Kohberger, was there or was maybe even out of state at the time, the court may find that there's no relevance whatsoever. Next on the docket, a Georgia couple gets sentenced to 100 years for one of the worst crimes you can possibly do. So 2 men who were convicted in a abuse of their 2 adopted sons are headed to prison for the rest of their lives. So a judge decided that a married gay couple, William and Zachary Zulak, once apparently quite the darlings of the LGBTQ scene in Georgia, will each serve 100 years in prison for sodomizing their young sons, recording these acts, and providing videos of the abuse to other pedophiles. This abuse was believed to have taken place when the boys were young as 3 and 5 years old. The 2 defendants truly created a house of horrors and put their extremely dark desires above everything and everyone else, the district attorney said at the sentencing. However, the depth of the defendant's depravity, which is as deep as it gets, is not greater than the resolve of those who fought for justice and the strength of the victims in this case. The resolve that the DA had seen for these 2 young men's victims over the last 2 years has been truly inspiring. So back in August, William Zulak pled guilty to aggravated sodomy, child molestation, incest, and 2 counts of sexual exploitation of a child. Zachary Zulak entered into his own guilty plea on October 21st for aggravated sodomy, child molestation, and sexual exploitation of children. And Zachary had a bench trial for the 2 incest counts and was found guilty by the judge. Following arguments from the prosecutors and the defense, The judge adhered to the state's recommendation and sentenced both men to 100 years behind bars without the possibility of parole, followed by probation for life if they ever get out. But due to the seriousness of their offenses, neither of them will be eligible for parole until their entire 100-year sentence has been concluded. Now, this case began against the couple back in July of 2022 when the Walton County Sheriff's Office got a tip from a Georgia Bureau of Investigation Child Exploitation and Computer Crime Unit. Investigators received an alert from the National Center for Missing and Exploited Children about suspected child abuse materials uploaded to a Google account with a Walton County IP address. After obtaining a search warrant, investigators raided the Zulok's home and discovered over 7 terabytes of digital evidence, home surveillance footage, and cell phone data that had contained graphic images, videos, and text messages discussing the abuse. In subsequent interviews, both men admitted they had spent years abusing their adopted sons that they actually adopted in 2018 from a now defunct Christian agency. This involved them the boys and forcing them to perform acts on them, is what they confessed to the police. The investigation into the Zuloks also revealed they were communicating with other files, a guy by the name of Hunter Lawless and Luis Vizcano Sanchez, about the abuse of their boys. Arrest documents said that Zachary Zulok messaged Lawless on Snapchat that he was going to F his son and to stand by. Lawless also told police that Zuloks offered their boys up to him multiple times. Lawless was arrested after downloading a large amount of that was traced to the police by his Gmail address. Now, Lawless admitted abuse materials from Zachary and was later sentenced to 20 years in prison, with the first 12 to be served in prison and then the remainder on supervised release. Now, incriminating messages from Zachary were also with Vizcano Sanchez's phone. He pled guilty to pandering for a person under the age of 18. After also pleading guilty to the unrelated crime of stealing computers from his workplace, Vizcano Sanchez was sentenced to 60 years, the first 15 of which will be served in prison. The couple was able to adopt their 2 sons, who are now 12 and 10, despite Zachary having been accused of another boy back in 2011. That allegation was reported to police but never investigated by prosecutors thoroughly enough to warrant charges. Now, Zachary Zulok and William Zulok were raising their sons in an affluent Atlanta suburb for roughly 3 years that they had custody of the boys. Now, Zachary worked for a local bank branch while William worked for a local government customer service center, but somehow the couple were raking in about $7,500 a week. They were able to build their dream home in an area where the properties sell for roughly $900,000. And behind the facade of a happy family in a beautiful home, the reality were that they were regularly their adopted children. Now, Zachary and Williams adopted the boys from foster care. The boys, then 5 and 3, had been removed from their heroin-addicted parents and placed in foster care. The pair said the abuse and the filming of that abuse occurred between 2019 and 2021. And then in 2021, just a year before they were arrested of heinous sexual abuse allegations, the pair made inquiries about adopting a 2-year-old girl. The adoption agency they used was All Good Children's Inc., a now defunct special needs agency in Georgia. It's unclear what kind of background check these two went through to formalize those adoptions. And I hate to say it, ladies and gentlemen, I've seen this before. You wouldn't think about it. You think people, and I'm sure that most people that adopt children are much better people than I would ever be. I know a gentleman that has adopted like 5 kids. He and his wife have a charity. They're just a better human being than I am. I assure you of that. But then I've seen this before where people adopt children to literally prey upon them. I've seen it. We've handled cases like this before over the years. It's horrible. 100 years is not enough time, but hopefully it's enough time that obviously they'll never, ever get out of prison. Next, on this day in legal history, December 24th, the Treaty of Ghent was signed in 1814, ending the War of 1812 between the United States and Great Britain. And the treaty restored the borders to the 2 nations to pre-war boundaries and resolved issues relating to territory disputes. Although signed on this date, news of the treaty did not reach the United States until weeks later due to the slow transatlantic communications at the time. On this day, on December 24th, 1919, the United States Supreme Court decided the case of U.S. v. Dormus, upholding the constitutionality of the Harrison Narcotics Tax Act of 1914. This law was one of the first federal statutes regulating narcotics, marking a key movement in obviously the development of drug control policies in the U.S. On this date in 1979, a high-profile mob informant entered society anonymously, marking the early operational use of the Witness Security Program, which later became central to organized crime prosecutions. And just to remember the dark side of our history, on December 24th, 1865, in Pulaski, Tennessee, the hate group, the KKK, was founded as a reaction to the Reconstruction efforts following the Union victory in the American Civil War. The group was later become notorious for its attacks against blacks, being targeted by the Enforcement Act of 1871, which imposed civil and criminal liability for deprivation of constitutional rights. Dark side there. And finally today, our dumb criminal of the day. A nursing aide pled guilty to hiding cocaine and marijuana inside a bowl of frozen lasagna that she tried to smuggle into the Indiana State Prison where she worked. Our contestant today, Regina Davis, pled guilty to felony narcotics charges in connection with an incident earlier this year that we brought you at the Indiana State Prison, a maximum security facility housing more than 2,000 adult males. A sentencing hearing for Davis, who is free on bond, is scheduled for January 31st. Now, Ms. Davis, who has been licensed as a certified nurse aide since 2003, was responsible for distributing medicine to inmates at the Michigan City lockup. In July, Ms. Davis arrived for work one morning toting a batch of lasagna that a guard thought looked odd as it passed through the X-ray machine, according to the affidavit for arrest warrant. A secondary examination of the lasagna turned up several packages wrapped in electrical tape that contained cocaine, about 3 ounces, and a little bit of pot thrown in there as well. During questioning, Ms. Davis claimed not to know the lasagna included an extra layer of controlled substance, adding that a female acquaintance had just given her 2 containers of lasagna to eat. Anyway, on Davis's phone, however, there contained photos of the drug packages that had been snapped earlier in that day. Now, Davis said that unknown individuals had threatened her safety, and that of her brother, who said apparently had just been released from prison, work release program there in South Bend, Indiana. Anyway, Ms. Davis claimed that she was instructed to go with a black guy to pick up the drugs. Anyway, the narcotics, she added, were to be picked up by the individual who stopped by the prison drug room and used the code phrase, "They were here to pick up some cream for their feet." Well, Ms. Davis, we brought you this story earlier in the year. We bring you the final result now. Here's a dumb criminal still. Don't take things into prison. I mean, think about it, ladies and gentlemen, if we can't keep stuff out of prison, I doubt we're going to be able to do anything else. And we clearly are not that good at it because it happens all the time. This is a prison offense. I'll be curious to see what happens at this sentencing because most judges take contraband introduction quite seriously and probably going to prison, Miss Davis. Probably going to prison. All right, ladies and gentlemen, that's all we have for you today. Happy Christmas Eve. Merry Christmas. Happy Hanukkah, happy Festivus, whatever you celebrate. Hope you enjoy it. We will see you Friday. Thanks for watching, and remember, the Constitution matters.